The Federal Rules of Evidence, Article 1, General Provisions. Rule 101, Scope. Definitions. Scope. These rules apply to proceedings in the United States courts. The specific courts and proceedings to which the rules apply, along with exceptions, are set out in Rule 1101. B. Definitions. In these rules, civil case means a civil action or proceeding. Criminal case means a criminal proceeding. Public office includes a public agency. Record includes a memorandum, report, or data compilation. A rule prescribed by the Supreme Court means a rule adopted by the Supreme Court under statutory authority. And 6. A reference to any kind of written material or other medium includes electronically stored information. Rule 502 references Rule 101. Rule 102, Purpose. These rules should be construed so as to administer every proceeding fairly, eliminate unjustifiable expenses and delay, and promote the development of evidence law to the end of ascertaining the truth and securing a just determination. Rule 103, Rulings on Evidence. A. Presuming a claim of error. A party may claim error in a ruling to admit or exclude evidence only if the error affects a substantial right of the party and 1. If the ruling admits evidence a party on the record, A. timely objects or moves to strike, and B. states the specific ground unless it was apparent from the context, or 2. If the ruling excludes evidence, a party informs the court of its substance by an offer of proof unless the substance was apparent from the context. B. Not needing to renew an objection or offer of proof. Once the court rules definitively on the record, either before or at trial, a party need not renew an objection or offer of proof to preserve a claim of error for appeal. C. Court's statement about the ruling, directing an offer of proof. The court may make any statement about the character or form of the evidence, the objection made in the ruling. The court may direct that an offer of proof be made in question and answer form. D. Preventing the jury from hearing inadmissible evidence. To the extent practicable, the court must conduct a jury trial so that inadmissible evidence is not suggested to the jury by any means. E. Taking notice of plain error. A court may take notice of a plain error affecting a substantial right even if the claim of error was not properly preserved. Rule 104, Preliminary Questions. A. In general, the court must decide any preliminary question about whether a witness is qualified, a privilege exists, or evidence is admissible. In so deciding, the court is not bound by evidence rules except those on privilege. B. Relevance that depends on a fact. When the relevance of evidence depends on whether a fact exists, proof must be introduced sufficient to support a finding that the fact does exist. The court may admit the proposed evidence on the condition that the proof be introduced later. C. Conducting a hearing so that the jury cannot hear it. The court must conduct any hearing on a preliminary question so that the jury cannot hear it if 1. The hearing involves the admissibility of a confession. 2. A defendant in a criminal case is a witness and so requests. Or 3. Justice so requires. Justice so requires. D. Cross-examining a defendant in a criminal case. By testifying on a preliminary question, a defendant in a criminal case does not become subject to cross-examination on other issues in the case. E. Evidence relevant to weight and credibility. This rule does not limit a party's right to introduce before the jury evidence that is relevant to the weight or credibility of other evidence. Rule 105. Limiting evidence that is not admissible against other parties or for other purposes. If the court admits evidence that is admissible against the party or for a purpose, but not against another party or for another purpose, the court, on timely request, must restrict the evidence to its proper scope and instruct the jury accordingly. Rule 106. Remainder of or related statements. If a party introduces all or part of a statement, an adverse party may require the introduction at that time of any other part or any other statement that in fairness ought to be considered at the same time. The adverse party may do so over a hearsay objection. Article 2, Judicial Notice. Rule 201, Judicial Notice of Adjudicative Facts. Judicial Notice of Adjudicative Facts. Scope. This rule governs judicial notice of an adjudicative fact only, not a legislative fact. B. Kinds of facts that may be judicially noticed. The court may judicially notice a fact that is not subject to reasonable dispute because 1. It is generally known within the trial court's territorial jurisdiction, or 2. Can be accurately and readily determined from sources whose accuracy cannot reasonably be questioned. C. Taken notice. The court may take judicial notice on its own, or 2. Must take judicial notice if a party requested and the court is supplied with the necessary information. D. Timing. The court may take judicial notice at any stage of the proceeding. E. Opportunity to be heard. On timely request, a party is entitled to be heard on the propriety of taking judicial notice and the nature of the fact to be noticed. If the court takes judicial notice before notifying a hearing, the party on request is still entitled to be heard. F. Instructing the jury. In a civil case, the court must instruct the jury to accept the notice fact as conclusive. In a criminal case, the court must instruct the jury that it may or may not accept the notice fact as conclusive. Article 3. Presumptions in civil cases. Rule 301. Presumptions in civil cases generally. In a civil case, unless a federal statute or these rules provide otherwise, the party against whom a presumption is directed has the burden of producing evidence to rebut the presumption. But this rule does not shift the burden of persuasion, which remains on the party who had it originally. Rule 302. Applying state law to presumptions in civil cases. In a civil case, state law governs the effect of a presumption regarding a claim or defense for which state law supplies the rule of decision. Article 4. Relevance and its limits. Rule 401. Test for relevant evidence. Evidence is relevant if it has a tendency to make a fact more or less probable than it would be without the evidence. And B, the fact is of consequence in determining the action. Rule 402. General admissibility of relevant evidence. Relevant evidence is admissible unless any of the following provides otherwise. The U.S. Constitution, a federal statute, these rules or other rules prescribed by the Supreme Court. Irrelevant evidence is not admissible. Rule 403, excluding relevant evidence for prejudice, confusion, time, waste of time, or other reasons. The court may exclude relevant evidence if its probative value is substantially outweighed by a danger of one or more of the following unfair prejudice. One or more of the following: unfair prejudice, confusing the issues, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence. Rule 404, character evidence, other crimes, wrongs, or acts. 1. A. Character evidence. 1. Prohibited uses. Evidence of a person's character or character trait is not admissible to prove that on a particular occasion the person acted in accordance with the character or trait. 2. Exceptions for a defendant or victim in a criminal case. The following exceptions apply in a criminal case. A. A defendant may offer evidence of the defendant's pertinent trait, and if the evidence is admitted, the prosecutor may offer evidence to rebut it. B. Subject to the limitations in Rule 412, a defendant may offer evidence of an alleged victim's pertinent trait, and if the evidence is admitted, the prosecutor may offer evidence to rebut it. And 2. Offer evidence of the defendant's same trait. In C, in a homicide case, the prosecutor may offer evidence of the alleged victim's trait of peacefulness to rebut evidence that the victim was the first aggressor. 3. Exceptions for a witness. Evidence of a witness's character may be admitted under Rules 607, 608, and 609. B. Other crimes, wrongs, or acts. 1. Prohibited uses. Evidence of any other crime, wrong, or act is not admissible to prove a person's character in order to show that on a particular occasion the person acted in accordance with the character. 2. Permitted uses. This evidence may be admissible for another purpose, such as proving motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accident. 3. Notice in a criminal case. In a criminal case, the prosecutor must A. Provide reasonable notice of any such evidence that the prosecutor intends to offer at trial so that the defendant has a fair opportunity to meet it. B. Articulate in the notice the permitted purpose for which the prosecutor intends to offer the evidence and the reasoning that supports the purpose. And C. Do so in writing before trial or in any other form during trial if the court for good cause excuses lack of pre-trial notice. Rule 405. Methods of proving character. A. By reputation or opinion. When evidence of a person's character or character trait is admissible, It may be proved by testimony about the person's reputation or by testimony in the form of an opinion. On cross-examination of the character witness, the court may allow an inquiry into relevant specific instances of the person's conduct. B. By specific instances of conduct. When a person's character or character trait is an essential element of a charge, claim, or defense, the character or trait may also be proved by relevant specific instances of the person's conduct. Rule 406. Habit, routine practice. Evidence of a person's habit or an organization's routine practice may be admitted to prove that on a particular occasion, the person or organization acted in accordance with the habit or routine practice. The court may admit this evidence regardless of whether it is corroborated or whether there is an eyewitness. Rule 407. Subsequent remedial measures. When measures are taken that would have made an earlier injury or harm less likely to occur, evidence of the subsequent measures is not admissible to prove. Negligence, culpable conduct, a defect in a product or its design, or a need for a warning or instruction, but the court may admit this evidence for another purpose, such as impeachment, or if disputed, proven ownership, control, or feasibility of precautionary measures. Rule 408. Compromise offers and negotiations. A. Prohibited uses. Evidence of the following is not admissible on behalf of any party, either to prove or disprove the validity or amount of a disputed claim, or to impeach by a prior inconsistent statement or a contradiction. 1. Furnishing, promising, or offering, or accepting, promising to accept, or offering to accept a valuable consideration in compromising or attempted to compromise the claimant. 2. Conduct or a statement made during compromise negotiations about the claim, except when offered in a criminal case and when the negotiations related to a claim by a public office in the exercise of its regulatory, investigative, or enforcement authority. B. Exceptions. The court may admit this evidence for another purpose, such as proving a witness's bias or prejudice, negating a contention of undue delay, or proving an effort to obstruct a criminal investigation or prosecution. Rule 409. Offers to pay medical or similar expenses. Evidence of furnishing, promising to pay, or offering to pay medical, hospital, or similar expenses resulting from an injury is not admissible to prove liability for the injury. Rule 410. Plea discussions and related statements. A. Prohibited uses. In a civil or criminal case, the evidence of the following is not admissible against the defendant who made the plea or participated in the plea discussions. 1. A guilty plea that was later withdrawn. 2. A nolo contendere plea. A nolo contendere plea. 3. A statement made during a proceeding on either of those pleas under Federal Rule of Criminal Procedure 11 or a comparable state procedure. Or 4. A statement made during plea discussions with an attorney for the prosecuting authority if the discussions did not result in a guilty plea or they resulted in a later withdrawn guilty plea. B. Exceptions. The court may admit a statement described in Rule 410A3 or 4 in any proceeding in which another statement made during the same plea or plea discussions has been introduced if, in fairness, the statements ought to be considered together. Or 2. In a criminal proceeding for perjury or false statement if the defendant made the statement under oath on the record and with counsel present. Rule 411. Liability insurance. Evidence that a person was or was not insured against liability is not admissible to prove whether the person acted negligently or otherwise wrongfully. But the court may admit this evidence for another purpose, such as proving a witness's bias or prejudice or proving agency, ownership, or control. Rule 412. Sex offense cases. The victim's sexual behavior or predisposition. A. Prohibited uses. The following evidence is not admissible in a civil or criminal proceeding involved alleged sexual misconduct. 1. Evidence offered to prove that a victim engaged in other sexual behavior. 2. Evidence offered to prove a victim's sexual predisposition. B. Exceptions. 1. Criminal cases. The court may admit the following evidence in a criminal case. A. Evidence of specific instances of a victim's sexual behavior. If offered to prove that someone other than the defendant was the source of semen, injury, or other physical evidence. B. Evidence of specific instances of a victim's sexual behavior with respect to the person accused of the sexual misconduct. If offered by the defendant to prove consent, or if offered by the prosecutor. And C. Evidence whose exclusion would violate the defendant's constitutional rights. 2. Civil cases. In a civil case, the court may admit evidence offered to prove a victim's sexual behavior or sexual predisposition if its probative value substantially outweighs the danger of harm to any victim and of unfair prejudice to any party. The court may admit evidence of a victim's reputation only if the victim has placed it in controversy. C. Procedure to determine admissibility. 1. Motion. If a party intends to offer evidence under Rule 412b, the party must A. File a motion that specifically describes the evidence and states the purpose for which it is to be offered. B. Do so at least 14 days before trial unless the court, for good cause, sets a different time. C. Serve the motion on all parties. And D. Notify the victim or, when appropriate, the victim's guardian or representative. 2. Hearing. Before admitting evidence under this rule, the court must conduct an in-camera hearing and give the victim and parties a right to attend and be heard. Unless the court orders otherwise, the motion, related materials, and the record of the hearing must be and remain sealed. D. Definition of victim. In this rule, victim includes an alleged victim. Rule 413, similar crimes in sexual assault cases. A. Permitted uses. In a criminal case in which a defendant is accused of a sexual assault, the court may admit evidence that the defendant committed any other sexual assault. The evidence may be considered on any matter to which it is relevant. B. Disclosure to the defendant. If the prosecutor intends to offer this evidence, the prosecutor must disclose it to the defendant, including witnesses' statements or a summary of the expected testimony. The prosecutor must do so at least 15 days before trial or at a later time that the court allows for good cause. C. Effect on other rules. This rule does not limit the admission or consideration of evidence under any other rule. D. Definition of sexual assault. In this rule, in Rule 415, sexual assault means a crime under federal law or under state law, as state is defined in 18 U.S.C. Section 513, involving 1. Any conduct prohibited by 18 U.S.C. Chapter 109A. 2. Contact without consent between any part of the defendant's body or an object in another person's genitals or anus. 3. Contact without consent between the defendant's genitals or anus or any part of another person's body. 4. Deriving sexual pleasure or gratification from inflicting death, bodily injury, or physical pain on another person. Or 5. An attempt or conspiracy to engage in conduct described in subparagraphs 1 through 4. Rule 414. Similar crimes in child molestation cases. A. Permitted uses. In a criminal case in which a defendant is accused of child molestation, the court may admit evidence that the defendant committed any other child molestation. The evidence may be considered on any matter to which it is relevant. B. Disclosure to the defendant. If the prosecutor intends to offer this evidence, the prosecutor must disclose it to the defendant, include witnesses' statements or a summary of the expected testimony. The prosecutor must do so at least 15 days before trial or at a later time that the court allows for good cause. C. Effect on other rules. This rule does not limit the admission or consideration of evidence under any other rule. D. Definition of child and child molestation. In this rule, in 415, 1. Child means a person below the age of 14. And 2. Child molestation means a crime under federal law or under state law, as state is defined in 18 U.S.C. Section 513, involving A. Any conduct prohibited by 18 U.S.C. Chapter 109A and committed with a child. B. Any conduct prohibited by 18 U.S.C. Chapter 110. C. Contact between any part of the defendant's body or an object and the child's genitals or anus. D. Contact between the defendant's genitals or anus and any part of a child's body. E. Deriving sexual pleasure or gratification from inflicting death, bodily injury, or physical pain on a child. Or F. An attempt or conspiracy to engage in conduct described in subparagraphs A through E. Rule 415. Similar acts in civil cases involving sexual assault or child molestation. A. Permitted uses. In a civil case involving a claim for relief based on a party's alleged sexual assault or child molestation, the court may admit evidence that the party committed any other sexual assault or child molestation. The evidence may be considered as provided in Rules 413 and 414. Disclosure to the opponent. If a party intends to offer this evidence, the party must disclose it to the party against whom it will be offered, including witnesses' statements or a summary of the expected testimony. The party must do so at least 15 days before trial or at a later time that the court allows for good cause. See effect on other rules. This rule does not limit the admission or consideration of evidence under any other rule. Privileges. Rule 501. Privilege in general. The common law is interpreted by the United States courts in the light of reason and experience governs a claim of privilege unless any of the following provides otherwise: the U.S. Constitution, a federal statute, or rules prescribed by the Supreme Court. But in a civil case, state law governs privilege regarding a claim or defense for which state law supplies the rule of decision. Rule 502. Attorney-client privilege and work product. Limitations on waiver. The following provisions apply in the circumstances set out to disclosure of a communication or information covered by the attorney-client privilege or work product protection. Disclosure made in a federal proceeding or to a federal office or agency. Scope of a waiver. When the disclosure is made in a federal proceeding or to a federal office or agency and waives the attorney-client privilege or work product protection, the waiver extends to an undisclosed communication or information in a federal or state proceeding only if 1. The waiver is intentional. 2. The disclosed and undisclosed communications or information concern the same subject matter. And 3. They ought in fairness to be considered together. B. Inadvertent disclosure. When made in a federal proceeding or to a federal office or agency, the disclosure does not operate as a waiver in a federal or state proceeding if 1. The disclosure is inadvertent. 2. The holder of the privilege or protection took reasonable steps to prevent disclosure. 3. The holder promptly took reasonable steps to rectify the error, including, if applicable, following the Federal Rule of Civil Procedure 26B5B. C. Disclosure made in a state proceeding. When the disclosure is made in a state proceeding and is not the subject of a state court order concerning waiver, and is not the subject of a state court order concerning waiver, the disclosure does not operate as a waiver. In a federal proceeding, if the disclosure 1 would not be a waiver under this rule if it had been made in a federal proceeding, or 2 is not a waiver under the law of the state where the disclosure occurred. D. Controlling effect of a court order. A federal court may order that the privilege or protection is not waived by disclosure connected with the litigation pending before the court, in which event the disclosure is also not a waiver in any other federal or state proceeding. E. Controlling effect of a party agreement. An agreement on the effect of disclosure in a federal proceeding is binding only on the parties to the agreement unless it is incorporated into a court order. F. Controlling effect of this rule. Notwithstanding Rules 101 and 1101, this rule applies to state proceedings and to federal court annexed and federal court mandated arbitration proceedings in the circumstances set out in the rule. And notwithstanding Rule 501, this rule applies even if state law provides the rule of decision. G. Definitions. In this rule, attorney-client privilege means the protection that applicable law provides for confidential attorney-client communications. And 2. Work product protection means the protection that applicable law provides for tangible material or its intangible equivalent prepared in anticipation of litigation or for trial. Witnesses. Rule 601. Competency to testify in general. Every person is competent to be a witness unless these rules provide otherwise, but in a civil case, state law governs the witness's competency regarding a claim or defense for which state law supplies the rule of decision. Rule 602. Need for personal knowledge. A witness may testify to a matter only if evidence is introduced sufficient to support a finding that the witness has personal knowledge of the matter. Evidence to prove personal knowledge may consist of the witness's own testimony. This rule does not apply to a witness's expert testimony under Rule 703. Rule 603. Oath or affirmation to testify truthfully. Before testifying, a witness must give an oath or affirmation to testify truthfully. It must be in a form designed to impress that duty on the witness's conscience. Rule 604. Interpreter. An interpreter must be qualified and must give an oath or affirmation to make a true translation. Rule 605. Judge's competency as a witness. The presiding judge may not testify as a witness at the trial. A party need not object to preserve the issue. Rule 606. Juror's competency as a witness. A. At the trial. A juror may not testify as a witness before the other jurors at the trial. If a juror is called to testify, the court must give a party an opportunity to object outside the jury's presence. B. During an inquiry into the validity of a verdict or indictment. 1. Prohibited testimony or other evidence during an inquiry into the validity of a verdict or indictment. A juror may not testify about any statement made or incident that occurred during the jury's deliberation, the effect of anything on that juror's or another juror's vote, or any juror's mental processes concerning the verdict or indictment. The court may not receive a juror's affidavit or evidence of a juror's statement on these matters. 2 exceptions. A juror may testify about whether A. extraneous prejudicial information was improperly brought to the jury's attention, B. an outside influence was improperly brought to bear on any juror, or C. a mistake was made in entering the verdict on the verdict form. Rule 607. Who may impeach a witness? Any party, including the party that called the witness, may attack the witness's credibility. Rule 608. A witness's character for truthfulness or untruthfulness. A. Reputation or opinion evidence. A witness's credibility may be attacked or supported by testimony about the witness's reputation for having a character for truthfulness or untruthfulness, or by testimony in the form of an opinion about that character. But evidence of truthful character is admissible only after the witness's character for truthfulness has been attacked. B. Specific instances of conduct. Except for a criminal conviction under Rule 609, extrinsic evidence is not admissible to prove specific instances of a witness's conduct in order to attack or support the witness's character for truthfulness. But the court may, on cross-examination, allow them to be inquired into if they are probative of the character for truthfulness or untruthfulness of 1. the witness, or 2. another witness whose character the witness being cross-examined has testified about. By testifying on another matter, a witness does not waive any privilege against self-incrimination for testimony that relates only to the witness's character for truthfulness. Rule 609. Impeachment by evidence of a criminal conviction. A. In general, the following rules apply to attacking a witness's character for truthfulness by evidence of a criminal conviction. 1. For a crime that in the convicting jurisdiction was punishable by death or by imprisonment for more than 1 year. The evidence, A. must be admitted subject to Rule 403 in a civil case or in a criminal case in which the witness is not a defendant. And B. must be admitted in a criminal case in which the witness is a defendant if the probative value of the evidence outweighs its prejudicial effect to the defendant. And 2. For any crime regardless of the punishment, the evidence must be admitted if the court can readily determine that establishing the elements of the crime required proving or the witness is admitting a dishonest act or false statement. B. Limit on using the evidence after 10 years. This subdivision B applies if more than 10 years have passed since the witness's conviction or release from confinement for it, whichever is later. Evidence of the conviction is admissible only if 1. its probative value, supported by specific facts and circumstances, substantially outweighs its prejudicial effects, and 2. the proponent gives an adverse party reasonable written notice of the intent to use it so that the party has a fair opportunity to contest its use. C. Effect of a pardon, annulment, or certificate of rehabilitation. Evidence of a conviction is not admissible if 1. the conviction has been the subject of a pardon, annulment, certificate of rehabilitation, or other equivalent procedure based on the finding that the person has been rehabilitated, and the person has not been convicted of a later crime punishable by death or by imprisonment for more than 1 year. Or 2. the conviction has been the subject of a pardon, annulment, or other equivalent procedure based on a finding of innocence. D. Juvenile adjudications. Evidence of a juvenile adjudication is admissible under this rule only if 1. it is offered in a criminal case. 2. the adjudication was of a witness other than the defendant. 3. an adult's conviction for that offense would be admissible to attack the adult's credibility. And 4. admitting the evidence is necessary to fairly determine guilt or innocence. E. Pendency of an appeal. A conviction that satisfies this rule is admissible even if an appeal is pending. Evidence of the pendency is also admissible. Rule 610. Religious beliefs or opinions. Evidence of a witness's religious beliefs or opinions is not admissible to attack or support the witness's credibility. Rule 611. Mode and order of examined witnesses and presenting evidence. A. Control by the court. Purposes. The court should exercise reasonable control over the mode and order of examining witnesses and presenting evidence so as to 1. make those procedures effective for determining the truth, 2. avoiding wasting time, and 3. protect witnesses from harassment or undue embarrassment. B. Scope of cross-examination. Cross-examination should not go beyond the subject matter of the direct examination and matters affecting the witness's credibility